Le mai, as felt Jeru, as Calcote. Good day, welcome, and go carefully. This video does not represent legal advice. Today I'm stood on the east bank of the Silverburn River, on the outskirts of Castletown, the ancient capital of the Isle of Man. On the opposite bank, in the distance, in the area of the ancient Abbey lands, is a field which was the site of a dispute in the 1740s that brought two significant families at the time head to head. That dispute would go on to define the law prohibiting no-win, no-fee agreements in the Isle of Man, a law that would go on to effectively stand for the next 230 years. In this video, I'm going to look at that dispute, the parties that were involved, the legal questions to be answered, and, significantly, how it went on to define the prohibition against no-win, no-fee agreements. I'll then reflect on the position today, significantly after Tynwald repealed that law in 1976. The dispute centred upon the question of entails in Isle of Man law. You might recall that in Jane Austen's famous novel Pride and Prejudice, the Bennet sisters were in despair, fearing the death of their father and being disinherited out of their family home in favour of the hapless Mr. Collins, their father's cousin. This was as a result of an entail, a clause that could be inserted into the transfer of property, a conveyance deed, in order to direct the future ownership of property. At the time Pride and Prejudice was written, entails were popular with the landed gentry in England in order to keep property within a family name. In effect, that meant prioritising male heirs and disinheriting female heirs. The land in question in the dispute in the 1740s was part of the Ballalockan's estate on the edge of Castletown. At the moment, I'm stood in the Ballallock Nature Reserve on the edge of Castletown, which was part of that estate. The estate was owned by the Calcote family, a significant family that had come from England and then been high profile in the Isle of Man in the 1500s, 1600s and 1700s, being MHKs, captains in the military, a deemster, and also a judge that was involved with the William Christian Ilium Dome trial. In the late 1600s, Arthur Calcote Sr. received the land at Ballallock, subject to an entail. That entail then directed that the property was to remain within the family. On his death, the property passed to his son, Turner Calcote. However, in Turner's hands, things changed. Turner Calcote, at the start of the 1700s, decided to parcel up the land at Ballallock and sell it on, contrary to the entail that should have kept it in his family. Some of that land was sold to Captain Stevenson of Balladule. Balladule also being a stately home on the edge of Castletown, just over in those tree line. The Stevensons of Balladule were also a high-profile family in the Isle of Man who had been MHKs, captains in the military, and also later a deemster. After about 20 years, Turner Calcote's son, Arthur Calcote Jr., decided to challenge the sale of the land. He brought a case in the mid-1740s. Although the records are a bit patchy, it seems like he might have first brought a case in the land court, but then ultimately the House of Keys heard that case. You might be surprised at that, thinking about the House of Keys today as part of the legislature, but it did function in that way at the time. However, Arthur Calcote lost, and it was decided that the land could have been sold by Turner Calcote and wasn't subject to the entail. At least it didn't have legal effect to stop the sale. Arthur Calcote wasn't happy with this. So I'm now stood in Castletown, just outside the old House of Keys building. The House of Keys sat here as an assembly from the early 1700s, initially just on the ground floor, but by the early 1800s they had taken over the entire building as their seat in the Isle of Man. Prior to the 1700s they had sat in Castle Rushen, which is just across the road, on an ad hoc basis when called together. Now, Arthur Calcote, he had lost his first case, which some records suggest had been a judgment of the House of Keys, sitting as a court, not as a legislative chamber as we'd know today. And unhappy at that outcome, and of not having regained the lands at Balaloch, he appealed the case to the Lord of Man, the second Duke of Atholl. The Dukes of Atholl had inherited the Isle of Man from the Earls of Derby, who had been initially kings of the Isle of Man, then lords of the Isle of Man after a grant from Henry IV, the King of England, in 1405. Now, the Lord of Man, faced with the question on the appeal, the legality of entails under Isle of Man law, sought sensibly the assistance of the Deemsters, the Isle of Man judges. The Deemsters were described as the repository of the law, holding the law in their breast and then declaring the law. And at the time there were two Deemsters, a northern Deemster and a southern Deemster, and it was Deemster Milray who gave the opinion to the Lord of Man, and that said that Isle of Man law was different to laws of England, a fundamental point, and there was no record and there was no statutory or customary law that said the entails had been part of the law of the Isle of Man. And therefore, as there was no law on the entails, that they had no effect in prohibiting the sale from Arthur Calcote's father, Turner Calcote, to Captain Stevenson of the land at Balaloch. The Lord of Man, having received the opinion, gave judgment in favour of Captain Stevenson and said that the land had been validly sold, and therefore the case was lost. Now Arthur Calcote there and could have taken the case further. He could have appealed the case to the Privy Council in London. There was a case about 40 years earlier called Christian versus Corrin, which declared that the Privy Council in London could hear appeals from the Isle of Man, and that's the position today. The final court of appeal from the Isle of Man is the Judicial Committee of the Privy Council in London. But the records don't suggest that Arthur Calcote had attempted that. It would have been a very expensive step to take. So that was the end of the saga. But there was a very interesting aspect in this case that's still very relevant today, and that is that the record suggests that Arthur Calcote was represented by a lawyer throughout the case, an attorney, Mr. Gill, what we would now describe as an advocate, and the record suggests that the advocate, Mr. Gill, was representing him on a no-win, no-fee agreement basis, and on the basis that if he won the case for Arthur Calcote, he would take a share of the land at Balaloch as his reward. And there's even the records also suggest that he advised his client, Mr. Calcote, to reject an offer of settlement which would have resolved the case earlier. Now, the authorities in the Isle of Man, the Lord of Man, Patrick Lindsay, his governor, and some elements of the House of Keys, the records suggest, were quite aggrieved by this long-going litigation and the disruption it had caused for the people at the time. So they decided to pass a law that would prohibit no-win, no-fee agreements and stop this kind of litigation taking place. And that law was called the Shampty Act 1747. And the Shampty Act was restated again on the same terms in 1777 in a different law. And that law then lasted for 199 years until 1976, when Tynwald decided to repeal the prohibition, the statutory prohibition on no-win, no-fee agreements. So they removed that statutory bar on no-win, no-fee agreements. Now, that was the position until the Isle of Man Law Society took it upon itself to introduce its own prohibition on its members, prohibiting them, advocates, Isle of Man advocates, from entering into no-win, no-fee agreements with clients for Isle of Man court cases. So Tynwald had repealed its ban on no-win, no-fee agreements, its prohibition, and then after that, the Isle of Man Law Society in 1989 decided to introduce its own prohibition, in effect, on its members. So litigants in the Isle of Man couldn't enter into no-win, no-fee agreements because they couldn't find advocates to accept them, unless the Isle of Man Law Society waived that prohibition on a case-by-case basis. And that's where we stand today, with that prohibition still in existence, restated in 2024, despite Tynwald having removed its own prohibition in 1976. Now, if you're interested in this video and learning more, look out for my next video on maybe the oldest trust in the Isle of Man, or one of the oldest trusts, and maybe one of the most famous trusts, and an egregious abuse of power that took place in its settlement, which related to the lands where King William's College was built. So look out for that video, like the channel, and good day and good health. Ban at Liat as Slant Fi.